Hi, everyone. I'm Gene Richards, attorney from the Williams Law Group, and welcome back to the Navigating DCP&P podcast, the podcast where we break down complex issues involving the Division of Child Protection and Permanency, or DCP&P. Before I get into today's episode, I want to remind all of you listening that any information I share does not create an attorney-client relationship, but we do welcome any person involved with the child welfare agency, being DCP, to contact our office for a confidential consultation with our team. On today's episode, we're going to break down a very complex issue, that being medical neglect allegations. What constitutes medical neglect? Under New Jersey law, it is the failure to provide necessary medical care that could seriously endanger the child's health. That might include missing important appointments with doctors, with a pediatrician. It might include refusing certain treatments, required surgeries or medications, or sometimes pursuing alternative care or medicine rather than the typical conventional care that you more commonly see. Now, there are a lot of gray areas, as are most situations with DCP and the law in general, where a parent has to balance the side effects or the risks or second, third, fourth opinions from other doctors as to what should happen next. Also, differing cultural or religious beliefs about medicine, about medications, vaccines, types of procedures being done, and so forth. So what impact does the potential threat or allegation of medical neglect cause on families? What impact does it have on parents and families and kids? You kind of have to weigh the balance of the parents' rights versus state oversight. So parents are presumed to know what's best for their child, but the state and DCP&P can intervene if a referral is made and DCP&P finds and believes that child's health is endangered. Idea of best interest, right? We're saying here in this situation, parents presume to know what's best for the child, but we know that a very key phrase in the family court and with DCP&P is the best interest of the child. And so sometimes a call comes in and the division may believe that a parent is not putting that child's best interest in play by refusing certain treatment or medication or not going to doctor appointments or having care that needs to happen, medically speaking. This can be included, or this can occur in simple cases or complex cases. It can be chronic illnesses. It could be mental health treatment. That's right. You might think like, well, the pediatric appointments and things like that matter, but also counseling and mental health treatment, right? Therapy. Those things are obviously important as well. Very serious situations like life-saving interventions, whether it be surgeries or transfusions or chemotherapy. Obviously, by refusing certain recommendations or prescribed medication, there can be dire consequences and dire and serious outcomes. And by not putting your child's best interest at heart and following recommendations that are given to you, that may lead to allegations of medical neglect, which can lead to removals and court orders for treatment or findings of abuse or neglect, in this case, medical neglect, that follow the parent around for forever with those findings. And so it's important to know your rights, know what you can do. Now, hear me out on this one, that, as a parent, that's correct, right? You're presumed to know what's best for your child, and you can fight for your child. You can be a voice for your child, but let it be known that the division, the state, can intervene if a call is made. For example, I'll give you a clear example. A doctor recommends certain treatment and a parent says no. If that doctor feels that by not doing that treatment, by not complying with the recommendation, may cause harm to your child, that doctor may call DCP&P and say, hey, this parent is neglecting this child medically. That gets DCP&P involved, and now we're back on the trail of perhaps court and findings and so forth. I want to give you a real example that I've experienced in my cases, because as it's often the case, DCP&P can sometimes and oftentimes does intervene when it may not have had to. But of course, referrals come in and they get involved. And so in a specific case regarding medical neglect allegations, a client of mine had a child, a daughter, who was going through a lot, medically speaking. This child, her daughter, had some very, I would say, unknown medical conditions, diseases for that matter, that are not well known by many doctors in the the generic field, not well known by people in general. I don't think anyway. And so my client had her daughter in several different types of treatment specialists trying to just figure out really what is the underlying issue here. And as a result of these illnesses, her child looked sick. She was very thin, frail, didn't look well. And so although my client was doing the best she could do, having her child see specialists, evaluations, trying to figure out how we as a unit, the doctors and the parent, can help this child. Despite her doing that, the school sees a child come in and just has visual concerns, right? There was nothing really that was alarming in terms of the child saying anything, but just observations of a child looking like she was frail and not doing too well. DCP&P is called. And so now we have the state involved with a mother, a family here, who is already doing the right things. She has her daughter in seeing several specialists, figuring out how to best treat different illnesses or potential illnesses. You have the state at the worst time in a parent's life, right? Where a parent never wants to see their child suffer in any way. And you have my client's child suffering and not knowing how best to help it, figuring things out through doctors and through research from doctors and doing all that she can do. Now she has to have the state talk with her, speak with her, have her prove to the state that I'm doing the best I can. So we actually met with DCP&P at their office shortly thereafter to just provide them with ample evidence of all my client was doing, seeing this doctor and that specialist, going here, going to different states, different cities, different places where doctors knew about these diseases, top physicians in that field. And so just proof of all she had already done. And now you have DCP&P who is called by the school because there's visual concerns. And my client is now sitting in an office, spending time and hours and resources trying to prove that I'm doing all I can do. And that's really proof of, again, a very flawed system with DCP&P. And I understand as a lawyer, as an attorney, that, as we say before in many other podcast episodes, when DCP&P is called, they have to investigate. But perhaps the school could have done a little more investigating themselves. Ask the child, what's going on? Everything okay at home? Instead of just jumping to conclusions. And now having the state involved with a family who's doing all they can do, doing all the right things. There was evidence of doctor notes and recommendations, and every recommendation she is following. And despite that, a call is made to DCP&P, and she is now spending valuable time meeting with DCP, trying to prove that she's doing all she can do. Now, this case did not go to court, and this case closed out somewhat quickly. DCP&P, this is the other issue, right? When you have many doctors involved, once DCP&P is involved, they want to have releases and talk to the doctors who are involved to clarify that the parent is going here and is doing the recommendations and is following orders, trying to do everything right, and they're trying to confirm that she's doing that. That takes time to contact several different specialists and doctors, and so the case closed out relatively fast, but it wasn't overnight, and so she's spending weeks, maybe a month or two in this case, with DCP&P involved, and the stress of that and the oversight from the state when she was already doing all that she could do. So you have an allegation of medical neglect when you have a parent already doing all that she can do to make her child as healthy as she can be. And so in that specific case, right, we show the division that we've done all these things from A through Z. And sure, they did back out and close the case, and it was unfounded, but doesn't make the situation any better. It doesn't make it any more or less flawed because she had to have the state involved in the medical treatment of her child for really no reason besides a call coming in for weeks, 1 to 2 months around that time frame. And she was going through enough already. And then the child, had the division talk to her, and just a lot of extra stress that wasn't necessary. But because of the idea of medical neglect and allegation coming in, DCP is involved, and here we are. And so it really is important when you are doing, seeing different doctors and pediatricians and getting recommendations to, and this is common sense stuff, but you'd be surprised how many times common sense things don't happen. And when you're not ready for DCP&P or the state or anything for that matter, you're in a much worse spot. So keep these records, right? Or have them readily available, or know how to get them fast if you have to, because by having documentation of what this parent had done, it allowed for the case to wrap up much faster, and proof of, look, I'm doing all that I can. There's not neglect happening here, and it was unfounded. There was no evidence and proof of any neglect, but by having the documentation, by putting in the work, by doing all you can do to make sure your child's doing well, that allowed for the case to close out quickly. Other cases happen where a parent doesn't want to follow certain recommendations, right? And you as a parent, look, you have that right. Seek out second opinions, have your voice be heard, but it'll be difficult if you have 1, 2, 3, 4 doctors saying do something and you're not doing that. I can tell you, you're going to have DCP&P involved. But if you disagree with a doctor's opinion, then get a second opinion. You have that right, obviously. But at the end of the day, the courts find doctors to be experts. So if you have one expert saying one thing and nobody else saying anything different, the court and DCP&P defer to that expert. So and you have 2 experts saying one thing versus 0, same concept. It's just without having someone who's an expert in the field vouching for you or saying this should be happening or this should not be happening, it's going to be a tough case. It's like with evaluations, right? And if you have an evaluation and the report says do something and there's nothing to combat or refute that, your case is going to be very weak. So I know it's a very complex and really it's a controversial topic, but also very delicate, right? We're talking about your kids, your children, and you as a parent feel that, I know what my child needs. And of course, we do defer as parents to doctors and experts, but might disagree, right? And so you feel passionate about what your child needs. And so it's important to have a balance, right? You have your own feeling as a parent, what is best, but you also have to think what are those who know more saying as well. But ultimately, it's important to document, to do all you can do to ensure your child is doing well, healthy, and safe. And if that includes getting more than one opinion or going to a different doctor because a doctor you're going to isn't hearing your voice, then so be it. But don't be surprised if you're saying no to certain things that DCP&P is called. So be ready for that. But it doesn't mean you're doing anything wrong. And perhaps the call should not have been made in the first place. Perhaps there is no neglect, as in the case I mentioned a few moments ago. So, it's important to be aware of what can happen, but not allow that potential consequence to strike fear in you and say, you know what, I'm going to defer to whatever everybody else tells me to do. There's a balance. So it's important to have, of course, counsel as well to direct your steps in that and to help you communicate to DCP&P what you're doing. Because if you don't say it well or aren't able to lay out what you've done, it may come across as missing pieces or not doing things the right way. So it's important to really lay out what you have done and why it's the best way of doing things. I know, again, it's a difficult topic, but it's important, again, to just document, keep track, and just, again, do your best as a parent. Nobody's perfect. As always, I want to thank you all for listening, for tuning in, for learning with me, to hearing these conversations with me as well, and these prior stories of cases, and hopefully you don't experience that yourself, but if you do, you'll have an idea as to how to best handle those situations. We discuss medical neglect, what it is, how to best avoid it, how to best deal with DCP&P if a call comes in. And as always, if you are interested in learning more about the process, about cases that I've dealt with as examples, subscribe, share these episodes, share the podcast. We have resources on our website. We have resources on our social media pages, Facebook and Instagram. So feel free to follow and tune into those different areas of information and resources. And we'll, of course, as always, join back in for a new episode next week. Please tune in at that time. And until then, have a great week.